Good afternoon, everyone. My name's Kate Thomson, and with me today I have my colleague Tamsin Lawrence. Thank you for joining us for another Australian Business Lawyers and Advisors webcast. I was corrected on the correct terminology before we arrived here. We're really happy for you to be with us today to talk about a really important topic, one which has been in the media quite significantly in the last sort of 3 to 5 years, one which Tamsin in particular knows a lot about. So you're certainly going to get your money's worth today. We are, of course, talking about workplace sexual harassment and the new positive duty. So welcome, Tamsin. Thanks for being here.
Thanks for having me.
So do you want to take us a little bit through what we're going to be talking about today, a couple of the things we'll be focusing on and where we're going to end up, hopefully?
Absolutely. We're going to cover off just on some brief background and data to kick off. Then we're going to look at some of the recent legislative reforms that we've seen. And I think most of us are probably aware of the Respect at Work Act, but there's been a couple of other changes quite recently as well. So we'll cover off on those as well. We're then going to look at how do you actually meet the positive duty. There's all this chat around it. There's all these vague terms, but what is it practically speaking?
Sure.
What do you need to do? So we've broken it down. We're going to cover that all off today. So hopefully you'll leave with an answer to that one. We're then going to look at what are the risks of non-compliance. There's some really good lessons out of Victoria in particular. So we're just going to signpost those for you. And then we'll have hopefully a bit of time for some questions.
I'm not that convinced we will, given the amount of content we've got to go through, but we'll see what we can do. So before we sort of get into the media part of the topic, what we thought we might do is just set a little bit of background and context for why we've ended up where we are, despite the best endeavours of the legislature and a lot of the key players in the area. So Australia was actually a world leader, really, in attempting to introduce legislative frameworks to prevent and to support people going through sex-based discrimination, those kinds of things, sexual harassment, and indeed to make sure those things weren't happening both in the workplace and in our society more generally. So you can see there on the slide, we started back in 1984, so many, many years ago now. It becomes apparent as we go through this timeline, though, that maybe that didn't work out so well. So we had, of course, in the 2010s and 2020s, a number of significant high-profile cases. Most of you would probably recall back in 2010 we had David Jones receiving some very unfavourable media coverage in relation to the Christy Fraser Kirk case. Didn't stop there, unfortunately. No. We roll on through that decade, start to see the Me Too movement coming out of the US, having flow-on effects, of course, for people in Australia coming forward with their stories of what's happened to them. That then led to the Australian Human Rights Commission Respect at Work inquiry, which led to the report that we will talk a little bit about as being the basis for some of the legislative change that we're going to talk about today. Unfortunately, we've got all this stuff going on in the background, which is all great. We still continue to see some really significant high-profile incidents being reported out of institutions, you would think.
You would have thought Parliament, High Court.
You know, the ones that you probably would expect to know better, unfortunately, it just appears that this is a situation and an experience of many people in workplaces from very small to very large in our country, and that's what we're going to be trying to talk about today in an effort to stamp out some of those behaviours and give employers the tools that they need in their toolkits to make sure this is not happening in your workplace. At the bottom end of that slide there you can see, of course, there's been a flurry of legislative change in the past 3 years or so. I think we were talking before, Tamsin mentioned some of this stuff might have got caught up in coming out of COVID, it might have escaped your notice. So we're going to cover off on all of that so you've got a very clear understanding of where we need to be and what we need to do.
Absolutely. And we've recently seen the 5th national survey. So you probably have seen similar data to this before, but there was the most recent survey results that came out in November last year. And unfortunately, the numbers haven't moved very much at all.
So that top line there, 1 in 3 Australian workers have reported experiencing sexual harassment in the past 5 years.
That's 2 in every 5 men and 1 in every 4 women.
That's an extraordinary number of people. And obviously, and I think it's important for us to note at this juncture as well, there isn't a gender preconceived idea in the stuff that we're talking about today. This is stuff that we need to be thinking about in the context of all workers in our workplaces as well. So For me, I think one of the particularly concerning things are our statistics around people reporting sexual harassment and how few reports we're actually seeing. If we appreciate and accept the first number there around how many people experience sexual harassment. So only 18% of people who report sexual harassment occurring to them at work actually make a complaint.
Yeah, and for me, the more concerning figure is almost the next one after that, the fact that 41% of incidences are witnessed by people, but 65%, so majority of people don't actually try to intervene. And I think we'll talk about bystander intervention training a little bit later, and I think that's perhaps definitely directed at trying to improve those figures.
Yeah, definitely. I think, if you want to talk money, do we want to talk pure economic impact? $3.8 billion is the estimated cost to the economy. And then finally, over 1/3 of employees think their employer should be doing more to prevent and address sexual harassment. So perhaps unsurprising if we accept that 1 in 3 people have experienced sexual harassment in the past 5 years, a significant number as well think their employer should be doing more.
Now, this slide can be a bit of an overwhelming one, I think. A bit of a fun one for us to put together, I won't lie. But this is just sending the message that addressing sexual harassment is obviously incredibly important when it comes to reputation and community perception. But we know that there are other things that make it really important. We see impact on workplace culture, staff turnover, the devastating impact it can have, particularly when it's at the more egregious and serious end on those involved, and obviously legal costs and damages.
Absolutely.
But I think this is probably another good reminder that no one is immune from workplace sexual harassment, and it can have a real impact in the media and in the public perception of your workplace if you don't have steps in place to address it and address it quickly.
Yeah, because no one wants to end up on the front page of the newspaper, do they? I think as well, it's important to say at this point in time, this is a really complex area of the law, not just because, there's some complex concepts that we'll talk through in a moment, but just because of the number of touch points from a legal perspective there are. So you can see on that slide there's about 8 real sources of legal obligation. 4 of these have significantly changed in the past couple of years.
Yeah, 6 months, in fact, actually. We've seen changes to the Fair Work Act, to sex discrimination. We've seen changes to work health and safety and to the gender equality legislation. So we're going to touch upon each of those, but only in a very light manner. So if all of this is new to you, hopefully you'll leave today a little bit better informed, but perhaps with an awareness that this is very complex and it probably is a little bit more than an hour worth to get across.
And we could talk about it for much more than that, but I'm sure everyone doesn't want that on their first day back at work after a public holiday. The first legal concept we'd like to talk about, as Tamsin said, there is significant overlap between these sources of legal obligation, but this is a concept that really comes through in a lot of the sources of the legal obligation. So that's the meaning of sexual harassment. For our meaning, we go back to the Sex Discrimination Act, so that 1984 piece of legislation that we were meant to be the world leader around. So we have seen, again, some significant change in what we are actually talking about when we talk about sexual harassment. So you can see there on the slide the key kind of words and concepts, bolded and in blue. So a person sexually harasses another person if they make an unwelcome sexual advance or an unwelcome request for sexual favours, or engages in other unwelcome conduct of a sexual nature in relation to the person harassed. So that's the first part of what's actually happening. That concept of unwelcome conduct of a sexual nature is quite a broad one, isn't it?
Yeah, it is. And this is often where the point of dispute is between people. It's like, was it welcome? Was it unwelcome? That's usually where we see the debate, not so much usually around whether something is actually sexual in nature, although I must admit occasionally it does come up, particularly when you have things like text messages and emojis and certain touching and things like that. But definitely around that unwelcomeness, I think, is a bigger point of dispute.
Yeah, so we've got our conduct, something happened, and then the second part of the legal test is that bit down below. So in circumstances in which a reasonable person, having regard to all of the circumstances, would have anticipated the possibility that the person harassed would be offended, humiliated, or intimidated. And I think this is where sometimes we get a little bit tripped up, because this idea that you merely need to anticipate the possibility.
Low bar.
Low bar. Very low bar.
And it's also a lower bar than some of the state pieces of legislation. So if you've been referring to some states, you may notice that it's quite a higher bar than the possibility, but this is the definition that feeds through everything else. So.
Yeah. And the idea of the reasonable person in this context as well takes it away from, the relationship that the two parties might have. So that's quite often people who have a pre-existing personal relationship. There might be certain types of conduct that have been ongoing, might have been welcome. Having said that, the relationship can change, and we'll talk a little bit about that in a moment. And the situation becomes, significantly altered because of these ideas of reasonableness that are introduced into the legal construct.
Absolutely. We're going to quickly go through this. This actually hasn't changed recently. It changed back in September 2021, but no doubt everyone was probably pretty tired at the end of COVID towards that end. So this might have just slipped through. It's around when sexual harassment is actually unlawful at work.
Sure.
And we've broken it down into two main categories that exist now. It's where either a certain relationship exists, so colleagues, you've got people who have a working relationship. Where we have that working relationship, everything else doesn't matter. So the physical location, the time, does not matter. If we've got a relationship and conduct occurs which meets that definition of sexual harassment, then it can be workplace sexual harassment just by the nature of us being in that working relationship.
So what you're saying there, Tamsin, is that even if the conduct doesn't occur at the workplace, there's literally no relationship to work other than the fact that that's how we know each other. That's where we get into this category.
It can still be, exactly. Now, the second category is a little bit closer to probably what people know about, but it is still a far broader than often people assume. And this is where we have conduct that occurs between one person who's doing their job and one other person who's not at all related to working in that workplace. So it could be myself and a customer and a client. In that circumstance, as long as I'm doing something in connection with my job, I don't actually necessarily have to be strictly doing exactly the task or job I'm set out to do, but I could be popping into the office for something or filling out a timesheet out of hours. So long as I'm doing something in connection with work, if the conduct occurs that meets that definition of sexual harassment, then it can be workplace sexual harassment as well.
And I think that's where, and we use the example of a hospitality environment quite frequently, and I think that's where we need to really have a quite broad understanding of what we're talking about here, because as you said, you can be at work personally. The person who's engaging in the harassment doesn't necessarily need to be a colleague of yours. It can be a visitor, a customer, a client, those sorts of people as well.
And this is all really important in understanding what your positive duty is, because when we get to that next, we'll realise there's a lot of steps you need to take, but you need to also understand what exactly are you trying to prevent and in what environment. And as you can see from this definition, it's incredibly broad. So possibly one of the most entertaining cases to come out of the courts of Victoria last year. I think that's a pretty high bar considering some spicy cases that came out last year. But this is one, and we won't get into the finer detail of the facts because it's overly convoluted. It involves some circus performers and someone who wrote a book about being in the circus and defamation.
Sure.
But the real message here is where an individual who was in the circus engaged in behaviour at the time which she said was welcomed. She had engaged in behaviour with another circus performer. But subsequent to that behaviour occurring, she then received text messages from that man's wife and realised that he perhaps had left out a few details about his private life.
No, exactly. Those details.
Exactly.
Right.
And so in the context of dealing with some other issues, the court looked at this issue and said, well, can unwelcomeness change over time? Can something that at the time is welcomed become unwelcome when you consider all of the circumstances, going back to that test about a reasonable person considering all of the circumstances? And in probably a very forward-looking case and maybe a sign of where things are to go in the future, the Victorian Supreme Court said yes. They said that it is possible that conduct that is welcomed at the time could subsequently become unwelcome because of future information that you find out.
Sure.
So I think a very big warning that the broadness of sexual harassment is only continuing to be broadened by the interpretation of the courts.
And do you think that has relevance where perhaps people are engaged in a consensual sexual relationship that then becomes, something happens, and that then becomes non-consensual? Is that kind of where we'll see that play out?
Yeah, and I think at the moment it's been a real clear line. If you've welcomed the behaviour initially, it's all fine. That wouldn't be sexual harassment. And we know that I think 1 in 3 people meet their partners in the workplace.
Yeah.
So the fact that this could now change that, if you find out some future information, maybe you find out about a cheating partner or a wife you didn't know about, I think that really does change the game. And I think something that employees need to be aware about as to where things might be going.
Sure. Okay. All right. Well, we've set the context, we've set the scene. Let's talk a little bit more about what exactly we're talking about from a technical perspective with those recent changes.
Absolutely. Well, this is the real guts of the changes, and this is what hopefully everyone is here to talk about today, the Respect at Work changes. We've highlighted only 4 of the main and key ones. There are a few other minor ones I must foreshadow with you, but the main ones, and we're going to go through each, so we'll cover in a bit more detail, but a high level, we've got the introduction of the new positive duty. And this is a positive duty that applies to all employers and PCBUs. So think of that work health and safety definition of who this covers. We've then got a lowering of the threshold for sex-based harassment. Now, don't worry, I'm sure probably a lot of people online are like, what does that mean? Is that sexual harassment? Is that something different? We'll talk about it, but it has been lowered to, I must admit, quite a low bar.
Okay, yeah.
Next, we're going to talk about the introduction of a new prohibition on conduct that subjects another person to a hostile workplace environment.
This is a really interesting one. And I use that word interesting loosely. It's a particular concern, I think.
Yeah.
If you're sitting there thinking, well, I might have a particular composition of my workforce that makes me not particularly concerned about some of these other offences as being high on my list of things to be aware of, this hostile workplace environment one, I think, needs to be, right up there on your list of priorities, even if you've made that assumption about some of the other things we might talk about today.
Absolutely. And last but definitely not least, we're going to briefly touch on the new powers of the regulator. So to both investigate and enforce, this is largely around the new positive duty, but we'll cover off on what they're going to be able to do come December this year.
Sure. Okay. Let's do positive duty. I think this is, as you said, probably why most people are here.
Absolutely.
So let's talk about that one first.
Well, the positive duty requires all employers and PCBUs to take reasonable and proportionate measures to eliminate, now not just sexual harassment, because I think that's what everyone assumes to be the case, but it's not just sexual harassment, it's sexual harassment, sex-based harassment, conduct that creates that hostile workplace environment, and victimisation.
That's a lot of obligation.
Quite a mouthful.
There. Yeah.
So we'll cover off on what each of the other ones are so you know, and we'll cover off on how you make sure that you address those in your positive duty. But it's important to realise that it's far broader than simply just ticking the box on sexual harassment.
And that, when we're talking about sexual harassment, if we just refer back that's the unwelcome conduct.
Absolutely, yeah. And we'll cover off on what this new sex-based harassment thing is, what this hostile workplace environment is. And hopefully everyone already knows what victimisation is, but just a reminder, you treat someone to their detriment because they've made a workplace complaint or something of that effect. Now, comparison with existing law.
Yeah.
What do you think? Is it different? People often say, look, this is just vicarious liability with another child.
Oh, I don't agree. I think it's quite a significant departure. Am I going to be howled down with taking that view? Or
no,
what?
I think those who said that, and no criticism to those who did before the legislation came in, I think that's really missing the point of what the positive duty is directed at. The positive duty is directed at improving all of the systems you put in place, whether or not you have a complaint made or not. And I like to think of it like a work health and safety obligation. Just because you don't have someone trip and fall on a ladder doesn't mean you've met your obligations to make sure they're not falling off the ladder.
Yeah, and I think that's the way I've been thinking about it, and that's the way I've been talking to clients about it, because it is a bit of a tricky legal concept to get our heads around if we're coming at it, completely fresh. So if you do think about it from that work health safety duty perspective, it does give you a little bit more of an understanding about, okay, it's not just about preventing and responding, it's about, anticipating and thinking about things which we might not have previously had regard to and what factors we need to put in place to control those risks.
Yeah, absolutely. Because previously the vicarious liability was a defence that people used when conduct had occurred that had met that test. An employer would turn around and say, look, I shouldn't be liable because here's my defence.
Yeah.
Unfortunately, at this point, a regulator can come in and look at you and look at your business and saying you're not meeting the positive duty even when no one complains, even when you've never had an incident of sexual harassment ever before.
Yeah.
And we do touch upon just at the bottom here the comparison with the work health and safety duty. As you can see, it's quite similar in that that's reasonably practicable, and here we have taking all reasonable and proportionate measures. So similar language, and I think we're going to cover off on some of the recent changes to that as well. There's quite a lot of crossover.
Yeah, there is. Yep.
Now the fun one, sex-based harassment. This is a new offence that was put into the legislation in late 2021, and I think most people probably, similar to the change to the definition of sexual
harassment, notice.
Didn't even notice it had popped in. I like to recast it personally. I think calling it sexism is probably just a far easier definition than sex-based harassment. But the government looked at the laws and said we have sex discrimination on one side, where you discriminate against someone because of their sex, and then we have sexual harassment. And they said there's this conduct that occurs in the middle that makes us feel uncomfortable, but that the law currently doesn't really cover.
So it doesn't fit neatly into one of those two categories.
Exactly. And they said, okay, we're going to create a new category. And that is essentially this definition. And if you're looking at the screen, I'm not going to read it out word for word, but it is very similar to that test in the second half that we have for sexual harassment, in that you've got the reasonable person having regard to all of the circumstances. Would they, again, anticipate the possibility of offending, humiliating or intimidating a person?
Sure.
But this time there's no sexual conduct. There's simply conduct that is demeaning in nature because of a person's sex.
Okay.
Now, you used to say seriously demeaning.
Okay, so we've even had a significant change in short period of time we've had the offence.
Exactly.
Right.
But that's what came in the Respect at Work changes. So we had this introduced in late 2021, and at the end of 2022, they said, look, frankly, no one actually even used this new law. Let's cut out seriously. We just don't want any demeaning conduct because of a person's sex to be occurring. And in reality, we're looking for sexist comments. We're looking at anything that might make someone feel lesser than they should in their work environment by nature of their sex. So comments about, for example, mothers being in the workplace and maybe needing to be at home looking after kids, or any of those common maybe terms that people use like man flu or dad bod.
Right.
There's every potential that they're captured if they're said in a manner that's demeaning to someone.
Okay. So again, just a really good reminder that, and I'll talk a little bit about this in a moment, about our next new offence. Some of the things and some of the ways that we've operated previously, some of the language that we've used, we're really going to have to reassess, reflect, and perhaps initiate some change to make sure we're not falling foul of any of these new offences.
Yeah, and I know we're going to touch upon how to meet the positive duty later, but if you don't currently cover this in your policy, you don't have it in your training, this is one, put a big star right on the page, sex-based harassment, you need to do an update.
All right, so let's talk about hostile workplace environments. It's now unlawful for an employer to subject another person to a workplace environment that is hostile on the grounds of sex. So kind of continuing on from what you were just talking about, but generally about the workplace, not about a particular person. And I think that's one of the real key changes when we're talking about this offence, is the workplace itself can be hostile on the grounds of sex if it satisfies the criteria on the screen there. But the conduct or the things that are happening need not have been directed towards any particular person.
So what kind of behaviour are we looking at when we're looking at this one?
Well, I think we're talking about things like, and I use this example a lot, the nude calendar on the crib room wall. If there's anyone out there who still has those in their workplaces, and I know that there are because I've had clients tell me about it recently, those need to go. If we have, a culture of banter and joking and those sorts of things that is sexual in nature, and again, we accept that there's particular workplaces where some of these things are going to have been accepted forms of relating and interacting with each other, and that's okay. We're not trying to be the fun police, but what we need to be aware of is we do need to be thinking about these sorts of intangible cultural factors, ways of relating to each other, forms of humour, jokes, those kinds of things, in the context of our sexual harassment and prevention of sexual harassment and other sex-based offences frameworks, which we will talk a lot more about in a moment. I think the other thing here, and again, we often have people asking about us about this particular aspect of some of these offences is, well, does anyone actually need to have been upset, offended, intimidated or humiliated, which is the legal test? And with this offence, we resoundingly say no.
Absolutely not. So someone doesn't even have to have the behaviour directed towards them to make the complaint in the first place. Hence being, you could have a calendar up. Obviously, that's not directed towards anyone. But if anyone walks into that workplace, whether or not they're your employee, they could be a customer, a client, anyone who's maybe a subcontractor on site. If they see it, they have an ability to complain to the regulator.
And I think that's a really good point, Tamsin, as well. And there's some case law around this particular type of instance occurring, is where you might have your workforce and you might have an accepted cultural standard of behaviour, those kinds of things. But then you have your subcontractor cleaning company come in.
Yes.
These are the sorts of people that we might need to have, a particular regard to when we're considering whether or not we're falling foul of some of these new legislative requirements.
Absolutely. And this is another one of those ones where we don't want any of our employees to engage in conduct that meets this new test. So we're going to need to re-educate, re-inform and let them know that whilst it might have been fine because you thought it was welcomed and it didn't meet that
no one was offended.
Sexual harassment definition, it now meets this new type of offence. So you're going to need to pull in that behaviour.
Yeah. Okay. All right, and then before we move on, just talking about that enforcement of the positive duty element that has been added in, because of course, there's no point adding in all of these new offences if we can't give someone the big stick to actually act in the compliance function. So the Australian Human Rights Commission has actually been given quite significant powers of assessment, monitoring and compliance to ensure that people are actually doing what they need to do in accordance with the Sex Discrimination Act. And again, even without a complaint being made or on foot. So here we've got this really interesting concept being introduced in a number of places in these legislative changes, whereby, a lot of people say to us, well, no, everyone gets along really well here,
No one's going to say anything.
No one's going to say anything. It's all fine. That's no longer going to be your salve or your protective mechanism, because what we can see here is that we do have these regulators having the capability to come in and investigate even where there has been no complaint. Of course, it's more likely to occur where there is a complaint, but I think it's important that we just draw attention to that as well.
And similar again back to that safety comparison, if you think of them like WorkSafe, whatever your state equivalent is, with that mentality that they might just appear at any time and start looking through and saying, what are you doing? If you have that mentality, I think you'll be in the best position to be able to say that you are meeting a positive duty.
Yeah. And similarly to your safety regulator or the Fair Work Ombudsman, they'll have the capacity to issue and enforce compliance notices, those kinds of things as well. So it won't just be a friendly little chat about what else you could be doing. It might be some significant, compliance enforcement mechanisms put in place. They can also go off to the federal court if they're really unhappy with you. So,
and I think as we're going to talk about a little bit later, Victoria has already had this positive duty in its work health and safety law for a little while. And as we've seen their regulator do, they really like to make somebody kind of the poster child for bad behaviour. So get your house in order and don't be the person that they come after and make an example of, I think is the message here.
And I think the other point to make on that point, just before we move on, is you've only got 7 months.
Yeah, it seems like a long time, but I'm sure it will dwindle away very quickly.
And when we're going to talk about all of the things that we recommend, I think there's a body of work there to do for a lot of people. So
absolutely. Now we're going to touch on just a few other acts that have changed where they interact with. So obviously, I'm sure everyone's more than aware of the Secure Jobs Better Pay Act that have made multiple amendments to the Fair Work Act. We're just touching very briefly on the changes in terms of sexual harassment. But for the first time, we now have a broad-based prohibition on sexual harassment in the Fair Work Act. Previous to this, we only had the Stop Sexual Harassment orders existing. But the definition, thankfully, is very similar, if not, frankly, the same, and taken from the Sex Discrimination Act. So where something's in connection with somebody's work and it meets that same definition that we've discussed earlier, it can now be raised in the context of the Fair Work Commission and the Fair Work Act. And as is up on the slide, we've got these 2 avenues that people can go down. Hopefully everyone was already aware of the Stop Sexual Harassment order. Or
they're very similar to the Stop Bullying orders, which people might be more familiar with.
Yeah, absolutely. So same kind of concept. We're trying to prevent future conduct from occurring. We've only seen a handful of cases, right? And not very successful. In every instance, in fact, an order was not granted because there was a sense that there was no future risk to the person. In most cases, they'd already left.
And I mean, that's been the ultimate experience we've had a lot with Stop Bullying orders as well, is that people who are experiencing these types of behaviours quite often will self-select out of the workplace. So haven't had that much usage of that jurisdiction to date, but what's your view on, now that the Commission has these expanded powers?
Well, now, in addition to the Stop Sexual Harassment order, we can also see what's called just the Fair Work Commission's power to otherwise deal with the dispute. Now, unhelpfully vague as always, but it basically means they can mediate, conciliate, or if you want to give agreement, they can arbitrate as well. And this power is really about remedying past behaviour. And I think it's fair to say that the Fair Work Commission has a pretty good profile in terms of helping people about workplace issues and disputes. So I'd say more so than any of the human rights bodies that we have. So I think it's probably more likely that we're going to see people start to use this avenue as a place to get some action taken or to remedy past ills that they may think have occurred.
So is that just so we're really clear, if I'm experiencing these sorts of behaviours at work, I could choose to go to the Fair Work Commission, or I could choose to go to the Human Rights Commission.
Yep, it's a choice, and that could go to the state regulator or to the federal regulator, being the Australian Human Rights Commission, or to the Fair Work Commission. And because you can kind of tack it alongside other things like a general protections claim, for example, it's a far more, I think, convenient jurisdiction for people to use. A lot more easy access, a lot more knowledgeable, lower cost, and all of those kind of things.
So what we're saying there is we're probably more likely to see, whilst we do talk about the Human Rights Commission and their power to hear these disputes, probably more likely to see them in the Commission.
Absolutely. And in terms of who can actually make the application?
This is very interesting. Again, just an extension of, you don't need to be worried about particular individuals, I think.
Yeah, well, a little bit concerning that now we can have union applications. So previously they could bring applications in the Human Rights Commission, but only at the point of mediation. They couldn't take it onto the court. They couldn't take it to the Commission. Evidently it didn't exist then, but now they can. And we can also see joint applications. So I think this is going to go to this cultural kind of feel that people are unwilling to come forward individually, but if they come as a pack, that whole Me Too feeling about things. It's going to be really interesting to see whether we see collective groups of employees take action against, whether it be a culture of a workplace that's wrong, or against an individual who maybe has wronged multiple
a number of people. Okay, yeah. And then finally, I think, and we were talking about this before, just on that last point there, some expanded anti-discrimination protections that you probably thought were in there already.
Yeah, I think nothing too controversial with those changes.
So we've mentioned work health safety a number of times here, and I think that it's important to sort of, emphasise that whilst these remain sort of separate and, distinct legal concepts, legal constructs and regulatory regimes, there is some significant overlap now, in the same way that there is with workplace bullying. In particular, and might be something that you've come across your desk, and we are doing a webinar later in the year on psychosocial hazards. I'll just put a plug in there for that one coming up in July, I think. But there is an increasing focus on psychosocial hazards from regulators, state and Commonwealth. What we mean by that is not just things like bullying and harassment. It's also things that might cause hazards to someone's psychological well-being caused by the environment in which they work. So basically, you can think about that as a really broad concept. Everything from job design to lack of supervision to too much supervision. So anything in the workplace that has the potential to cause someone to sustain or have a risk to their psychological safety. Sexual harassment in particular has been called out as one of these psychosocial hazards, and that's why we've got this slide here to talk about it in particular. So the other thing to be aware of, and somewhat helpfully, is that there is now a new code of practice dealing with the management of psychosocial hazards. So if you are thinking about this kind of stuff and going, I have no idea where to start, the code of practice is probably a good place to do that, in accordance with the usual workplace health and safety legislative regime. If you're doing what the code says you can do, that's putting you on a good path to defend the situation if the regulator comes knocking.
Similar though, I think we're going to talk about risk management
later. We
We
are. So just, I think, mentioning that there are a number of tools that are available and a number of interesting sources of information. So you actually need to be kind of just conscious of this isn't just an employment HR IR issue, this is also a safety issue as well.
Absolutely. Last but definitely not least, some recent changes to the Gender Equality Act and to reporting to WGEA. Hopefully, if you currently have to report, you're already aware that these changes have come in, but if you are not, it includes mandatory reporting for what's called relevant employers, so anyone with over 100 employees. And there's been a small change that was made in April, but quite significant for the purposes of sexual harassment, in the sense that there's now going to be mandatory reporting on the range of things that are up on the screen, but things around prevalence data, whether you've got a policy or not, support available to staff and things like that. And that's from April next year. So you've kind of, again, got a little while to get your house in order, but if you don't meet these mandatory reporting requirements, it can have an impact if you are receiving any government funding or government grants or tendering for any government work.
So do I need to be worried that these are going to be published?
They will be published, but in terms of the relevant employers, so those above 100, it's just the data that it will be published. You won't actually be what is actually occurring for those with more than 500 employers for the first time, and this is where they're required to have a policy or strategy in place.
Okay.
So that's the difference. So anyone over 100, your data is going to need to be reported and it's going to be public. Anyone above 500, all your data is going to be reported, as well as this requirement for you also to have either a policy or strategy. And I would say, given how big sexual harassment, sex-based harassment, it's probably going to be more of a strategy piece than just ticking the box and saying, I've got a policy.
Okay, sure. Goodness.
So
what do we do?
The meaty stuff. I know this is probably what everyone's been waiting for. We've hopefully laid the groundwork sufficiently to get us to this point. We've already talked about what is the positive duty. So it's this need to take all reasonable and proportionate steps. Now, as helpful as regulators are, and as legislation like this is, there is no actual guidance in terms of, we don't actually know practically what do we need to do, which is what everyone's asking the question. All that we know is that it's going to depend on a case-by-case basis. So they say, well, it's going to depend on the size of your business, operations, the circumstances, what your budget is, et cetera, et cetera.
So that classic lawyer response, which people love.
It's always unhelpful.
It depends.
Exactly. So if we flick to the next slide, as you can see, we've just tried to give you a little bit of a sense of how much stuff is out there from the regulators and how many different regulators are putting out information. And to be frank, it's all a little bit different, or use slightly different terminology. We know that the Human Rights Commission has 7 indicators.
Wow.
The Victorian regulator has 6 indicators. We've got all this change to work health and safety. But thankfully, we have taken the time to go through everything we can publicly find available, and we've turned our mind to, if you're sitting in front of a judge and he's saying, did you meet the positive duty? What are you really looking at? Because a lot of the stuff, it's going that next step further, but what are the essentials? And we've broken it down, and if we move to the next slide, this covers off on what we think are the 6 things you've got to have. If you don't have these, there's a big gaping hole, and if you do have a regulator come and inspect, or you do have a case of sexual harassment and it ends up in the courts and they turn and say, well, are you actually also meeting a positive duty? We think these 6 must be in place for you to have a good shot at being able to say you've met your positive duty.
So some of these things I think are going to be familiar to people, like policy, like training, and those sorts of things. I think the bottom line that I'm hearing is that, perhaps in the past when we've had a different statutory threshold, policy and training and those sorts of things might have been enough.
Yeah, and those trainings that are like the one you click online, maybe you've got it on the background, you're doing something else at the same time.
Not that we do that, of course.
But that kind of training is no longer sufficient. You've got to have some more interaction with people. You've got to have a clear awareness that they know what your policy is. Where can they locate it? Anyway, we'll go step by step and maybe break it down for you.
Let's start with knowledge and leadership. So I think we would summarise this as being, do people know what the issues are, what their responsibilities are, and is that fed down from the top? Do we have a culture where the CEO, the board, the management actually tell people about what's important to the company in this context, and actually role model good behaviours? And I think to do that, we need to make sure that those people are actually aware of a lot of the information we're going to be talking about today. So do they know what the offences are? What are the employer's obligations? Is that information being conveyed to our workforce so that everyone's on the same page about our expectation of behaviour, how to, be a positive bystander in circumstances where something might be happening that we don't agree with or think that's in accordance with our legal requirements or our cultural expectations.
And I think that former concept that might have come from boards and leadership, that's a HR issue, they'll manage it, is no longer going to fly. Your board, your leadership team, management, whatever that may be, they have to understand these concepts and they have to know what they mean, and they must understand what their positive duty obligation is. If they're not ticking that box, then it's a big red flag that your knowledge inside your organisation and your leadership from the top is not taking this issue seriously. Other things we might want to look for are like leaders modelling respectful behaviour, actively speaking about sexual harassment, promoting these kind of things in organisational values and codes of conduct. But a real base level is meeting those kind of questions that we put on the slide.
So that's all great, but that to me sounds pretty, stuff that is hard to track. It's hard to keep records of. How do we actually demonstrate? Because as you say, what we want to be doing with all 6 of these things is being able to say to the regulator or the judge, hey, look, here's all the things that we did. How do we do that with this one?
I think 2 main action items you must be taking. One is there must be some kind of training or knowledge-based learning from those in your management and your leadership. I would say formal training if you're a bigger organisation. If you're small and you're kind of at the smaller end of the business, you just want to make sure you yourself have got across all the detail. But if you've got a board, if you've got a leadership team, management, they must have undergone training on these issues and must have a keen awareness of it. And then some kind of evidence that they are taking it seriously and it's a priority. Now, that could be a regular agenda item on the board minutes. It could be the fact that you have regular, quarterly catch-ups about your action plan and what you're doing. But there needs to be something tangible that you can point to say, we're taking this seriously, it's on our agenda of top issues, and it's regularly being reported on back to the board, and they are taking a keen interest in what the plan is.
What if I'm a smaller business? And I think we need to remember here as well, a lot of the stuff that we talk about and a lot of the focus of the regulator seems to be on the big end of town, which is fine because, they have more resources and they have the responsibility. But what else do we need to be doing if we're a smaller business?
I think in terms of, if we just stop at knowledge and leadership for 2 seconds, in terms of a smaller business, you yourself just need to know about all of these laws and you need to be taking it seriously, actively speaking with your staff. But that's kind of the box tick for a small business, I think, at that end. But far more importantly, and this one is one for everyone, big, small, medium, everyone needs to do the same thing. It's in terms of a risk assessment. And this is this idea that you need to actually identify potentially the hazards that might cause or assist in sexual harassment occurring in your workplace. I know that sounds a bit crazy because you're like, how do I actually spot a sexual harasser? That sounds really difficult. But it is actually going through that typical risk assessment process that you would go through for any other type of safety concern. Now, we've put up on the slide, we've got kind of like a template checklist. So if you're worried and you're thinking, how do I do that? What are the things I need to go through? We can assist in that. But it's speaking with your workers. They're usually the ones who are going to know who's the creepy customer or the things that don't make them feel very confident.
The work practices or the particular parts of the environment.
Absolutely. What's the physical work environment? What about online? Have you done anything to address that? What about your workplace culture? That point about the banter happening. Again, looking at past incidents and claims. Do you have a problem area here that you haven't been looking at regularly? And then the big one and the most difficult, third parties. What are you actually doing in the workplace to address the risk that comes from customers and clients? They are the most difficult, but there are many things that you could be putting in place. And what you'll find in the risk assessment checklist that we've got the questions you ask yourself, you kind of tick off and think about them, and they've got suggested control measures, because there's no point identifying the risks if you don't then control them. It's like any other safety issue that you need to address. And because this is a work health and safety kind of in that same realm, again, we mentioned that unfortunate crossover that keeps happening with sexual harassment across all areas, you also need to meet your consultation obligations. But having a conversation with staff, asking them about their views and when they feel safe and not safe, for example, are you running a retail store where you've got people working alone or working late at night? Or, thinking about all those things and asking questions, that will meet that consultation obligation as well.
So I think if we just summarise that quickly with risk assessments. So the first step is actually doing the risk assessment, identifying the hazards, making an assessment of the risks that arise from those hazards. The second thing is, and probably, in conjunction with conducting that assessment, talk to people about it, because that's the best source of information, and probably will come up with some of your control measures as well.
That you might not have thought of.
And then the third part, and as you said, really important, is not just to go through that process of working out what's wrong, it's actually then going, okay, well, what are we going to do to control those risks as well, and making sure that we're actively on to implementing those control measures.
Absolutely. Now, one little point we'll just put at the bottom here, and I think this is just an interesting one. There is some sense that you could get this to be completed under the cover of legal privilege.
Right, okay.
Now, if you're out there and you're one of these companies that we kind of showed that big news article clipping of everyone, it's probably no point. It's probably legal privilege probably wouldn't cover it at that point. It's already in the public domain. But if you're kind of thinking, okay, I haven't really looked at this, I don't really want to fill something in that then on the public record that might bring to light some things that I might need to address sooner rather than later, it might be better to do that under the cover of legal privilege, then address them, and then move on to doing a regular audit yourself yearly.
Okay.
But that's an assessment you might need to make. It's in terms of how your business is currently looking.
Sure. Oh, the policy, like we said, hopefully not an unfamiliar concept to everyone, but what do we need to do differently to what we've done in the past?
Well, if your policy isn't up to date, as I've flagged earlier, this is the main big one.
Yep.
Check your policy. Is it up to date? Does it have sex-based harassment? Does it have conduct which contributes to a hostile workplace environment? If they're not covered, that's step number one.
Okay.
Who does it apply to? Hopefully everyone remembers at the very start, we talked about the fact that sexual harassment laws actually have far broader coverage than most people realise now. And often we see policies that are still back pre-2021 and have that more
employees.
Correct, have that more restrictive definition. So that's another important one. The other point is about having a standalone policy.
This is an interesting one.
It is a point of much contention.
Yeah.
But we know that a lot of people have incorporated them in these bullying and harassment policies. But the regulator's point of view,
now, standalone policy.
That's what they want.
Interesting. And I think this is something, and again, it'll depend on your resources and your, capability. But it might be that you go, all right, well, I think that there's enough, and there's certainly enough in the bullying. We know enough about bullying nowadays to be able to, create quite a comprehensive document itself. I think harassment's always been a bit of an adjunct, an add-on at the end of the bullying policy. Now we're saying, okay, let's put the two things separately. What else are we saying? Are we saying that we have to have different control measures, or are we saying different approaches to complaints and grievance handling?
Exactly, same kind of issue. And I think that's maybe why the regulator's saying standalone, because we will talk about dealing with complaints in a couple of slides' time. But it's really important that that's typically covered off in your own sexual harassment policy, that you've set that out and you set it out separately. So we would say, if you're at this point and you're like, okay, what do I need to do about my policy? Because this is probably the easiest of the whole bunch. It's check it's up to date. If you don't have an up-to-date one, step one, check that you've got a standalone policy. Now, it's not mandatory, but strongly, strongly encouraged. So if you need a policy that's separate, That's another thing. And review how are you actually communicating your policy to your staff. No good having a policy if nobody knows about it or doesn't know where to find it. And then finally, are you actually enforcing this policy? How have you been approaching complaints in the past?
Yeah, and that's a really big one when we talk about, if we get to the pointy end of a complaint where we're thinking about disciplinary action, if we've got a policy in place and we haven't followed it, that's going to be pretty poorly regarded by the commission or whoever's looking at our decision making leading up to that point of needing to make that call about disciplinary action, isn't it?
Yeah, absolutely. Now, in terms of where we can assist, because I suppose we are here to help you get through this as quickly and easily as possible, we do have a standalone policy. We also have a checklist that you can purchase. You can purchase either, or they're a part of our guide, which I think we'll get to at the end. But in terms of the standalone policy, I would just caution the ones that are out there from the regulators.
Sure.
They do have a few clauses in there that we would perhaps suggest tweaking a little bit. So just a word of warning if you are looking at downloading any of those regulator ones on the internet.
Okay, sounds great. All right, I think communication and training really flows on from policy, doesn't it? Because hopefully we've got our policy in place, which sets out our expectations, all of the legal things that we need to be covering off, in terms of what offences we're talking about, how we're going to actually articulate our expectations as to behaviour, how we're going to monitor and enforce compliance. But what we actually need to be doing is using that policy as a platform to say that, okay, we all know what we're talking about here now, hopefully, because we've done the knowledge and thought leadership as well in the background there. But we're actually saying to people, this is our expectation. These are the things that we think are important as a group and as a workplace and as a group of people who come together, and making sure that people are actually aware of those things as well.
Absolutely. And that's that same thing about setting that unequivocal message from your leadership team, saying that this is the behaviour we expect and we will not tolerate anything that strays into the sexual harassment, sex-based harassment type realm. And that communication, you need to keep records of it. We're looking at, email communication, posters, anything that you can think about the way you typically communicate with people should be the way that you're sending this message. And if you haven't sent that message before, or you've hidden it in an induction pack,
or in a handbook,
or in a handbook byline, that's not considered enough. And when it comes to training, I suppose we say communication and training because smaller businesses might not be in the kind of formal sphere. They might think of more like communication. But for those who have formal training approaches, you're probably going to need to update it. Does it cover sex-based harassment? Does it cover a hostile workplace?
Sure.
Does it explain to your employees what a positive duty is and what it means? You need to be explaining that to them. That's actually the expectation of the regulator. So again, in terms of what can we do to assist you in this one, if you're like, oh, my training isn't up to date, we will be touching on, again, the guidance material. As a part of that, we cover off on the knowledge section, and we have a wonderful video that explains all of these changes. That would be a great starting point to training people. And we also have what we call communication talking points. So if you want to run the training yourself and update people, we cover off on all of the things that are expected in a very nice talking point pack, so you can make sure you get all those definitions correct and you communicate all those key messages to your staff in a really concise but very clear way.
And I think as well, one of the things that, and again, trying to bring this back to, we're not just talking about the top end of town. We're really talking about this needing to be something that everyone, regardless of the size of your business, is talking about. So even if it is just, if you have toolbox talks, if you have staff meetings, that's the form of communication and training that will be appropriate to your business and the size and the resources that you have. So don't get too scared thinking about, oh my goodness, I've got to spend a whole heap of money on this stuff.
No.
By all means, if you've got a small number of employees, the mechanisms by which you can achieve compliance will be different. It's just about turning your mind to what those things might be.
Yeah, and exactly. And in the guide as well, we've got, as a part of this communication pack, I mentioned the talking points, but two of the other things in there are template emails, because we always know that can be a bit awkward. You want to get the language right, but you want to send the right message. There's two different versions there, and then we've got some posters that you can put around that are a little bit thought-provoking, I think, a little bit unusual, but again, something that's easy. Anyone can pick it up. Anyone can stick it in the workroom or on the lift well or whatever you use to where you typically put messages for people. The other type of training that we haven't touched on, bystander intervention.
It's a really good one as well. So, just as we said before, having people who are standing around, seeing things happen, empowering people to actually feel like they can say something and hopefully prevent things from escalating.
Yeah, absolutely. So one of the things we often get from people is, okay, well, I do my standard training, but what actually more do I need to do? If you are a small business, you probably, if you were to use the kind of talking points we've got and you get yourself up to speed on the knowledge and you communicate that to your employees, you've probably met the threshold. But if you're a medium to larger business, the regulator's looking for more. And bystander intervention training is really something that's been led in America and the UK. And it's a really great way of empowering your employees to have those open conversations with each other, but in a manner that keeps the relationship going long term. Because you don't want people calling people out and then you've got an awkward relationship going forward and people feeling guilty. So a strong recommendation, if you are a larger business and you're looking for something to do to kind of meet that requirement, definitely a big suggestion on bystander intervention training. I'm
just conscious of the time because, as expected, we have ended up talking a lot about some of these really important issues. So I think there's two really important things to cover off before we finish up today.
Absolutely.
One being complaint handling. And, this forms part of your policy. It forms part of how we're communicating about this stuff. But talk to us, Tamsin, about why this is really, really important.
This is so important because it's a real expectation from the regulator that not only are you preventing, but you're responding in the right manner.
Sure.
And it's safe to say probably this is the most difficult thing you've probably ever come up against, particularly if it's towards the more serious end of town. And I think that people often can freeze and don't know what to do and how do I operate in the right way and what's the procedure. And if you have all of that in place before the event occurs, one, you can help show the regulator that you take it seriously, that you have steps in place should a complaint arise, but it also helps you and whoever else is in the management team handle this complaint going forward. And it's also there's a huge emphasis by the regulator on employees knowing where they can complain.
And what they need to do.
And what's going to happen once they make a complaint. So that's another thing that needs to be part of your training and guidance. Hopefully it'll be in your policy, or if not, you can just grab the template one off the shelf from us. And that's key, that you're communicating with your employees where to go, because again, it's the same like with all of this. There's no point having it if nobody knows where it is and what to do.
Sure. Okay. And then finally, and this is, I think, the one which brings a lot of these themes together, which is, got all this stuff, I'm going to do all this work. How do I record it? What do I do? How do I demonstrate to the regulator when they come knocking that I have done everything I need to do?
Absolutely. Now, this is a big buzzword that the regulators seem to use, prevention plan. I think it's an unnecessary term to make it sound scary, big, horrible. In reality, a prevention plan is just a record of everything you're doing and everything you're going to do.
So all of the stuff that we've just done to be compliant with all of the other
those five
things?
steps. We're going to note them all down. We're going to put down there that we're sending communication email to staff, for example. And then we're going to write down that I sent an email on this day and this is who sent it out. And then when the regulator comes knocking and says, well, how have you actually even told your staff about sexual harassment and where they can report complaints? You can say, hang on this date, we sent this email to this many employees, for example, or on this date, X did this training. And yes, the training did include the updated materials on sex-based harassment. It's not as difficult as I think is made out. I think prevention plan can sound scary.
It does sound quite a labour-intensive prospect.
It does. Again, though, if you're looking for the cheats way of getting there, we do have a prevention plan template that kind of covers off on all of these steps that we've already talked about before. So if you're wanting to say, okay, yes, I'm going to follow the ones you've mentioned today and I want to make this easy for myself, definitely get in touch about the prevention plan template that you simply just have to fill it in when you do it.
I think that's just, before we move on, a really important point to make. It's about not just having the plan, it's about doing the things and that you say that you're going to do.
And keeping it up to date. That'd probably be my last point about the prevention plan. It's not something you can set and forget. You need to fill it in and then put it in your calendar and think, 6-12 months time, I'm going to come back, I'm going to look at it, I'm going to check in. It's that leadership point again.
Sure.
It all kind of links in, showing that you're taking the issue seriously and that you're looking at steps that you're taking and moving forward and addressing any issues that might arise.
Okay, sounds great. All right, well, oh goodness, we've done all of the things. What do we do? What happens, or what's our likely exposure if we don't do all of the things?
Well, our good friends Baker's Delight that unfortunate poster child I spoke about earlier.
Right.
As I mentioned, Victoria already has a positive duty. For anyone operating in Victoria, well done on scooting under the radar if you're kind of watching at the moment, because it's been in place there for a little while. Baker's Delight was the first, I suppose, victim, you could say, of the regulator. They were reviewed for 9 months, and I think they were relatively compliant. They kind of said, well, let us know what we need to be doing. And the compliance agreement that they were forced to enter into by the Victorian Equal Opportunity and Human Rights Commission is publicly available. You can go and click online and see what they were told. But one of the big things to come out of this is those third-party people that your staff come in contact with. The big criticism of Baker's Delight by the regulator is they weren't doing enough to address those third parties, the customers. They weren't tracking, problematic customers who were going from store to store, for example. And so that's a really good reminder about the need to have done that risk assessment and to put in place control measures and to have thought about all those different environments that we spoke about earlier.
So just to be clear, Tamsin, was there actually a complaint?
No, sorry, good reminder. No complaint? Nope.
So again, I just think a really interesting, a very sort of analogous to our traditional understanding of the safety regulators approach. You can just have the knock on the door one day and be in the same situation that Baker's Delight found themselves in.
Absolutely, and for the world to see.
What are some of our other risks? I think, we've talked about reputational damage quite a few times, and probably Baker's Delight would put that high on their list of concerns. But what are some of the other things that we talk about in this context?
I think staff turnover, low productivity, but the big one, and the one we're not going to cover off on all of them, but these damages that we're seeing out of the courts, they're big numbers, and traditionally the courts have been, I would say, a lag indicator. So usually they're 5 to 10 years behind community expectation when it comes to the amount of damages that they're awarding, and we're now seeing numbers in excess of 150,000 for run-of-the-mill expected type sexual harassment. I wouldn't say expected, but the standard types of sexual harassment.
That people perhaps wouldn't think of at the higher end of the egregiousness scale.
Absolutely, and we're only going to see these numbers get bigger. So again, if you're looking for an excuse to knock on someone's door and say, hey, I need to spend a bit more time on addressing the positive duty, this is a slide to come back to.
Yeah, okay. All right, well, I think we've given a bit of an idea about some of the things that we can do to help. There's some further sort of detail on that slide there. You've talked a little bit about our how-to guide. Do you want to go into a little bit more detail about that at this juncture?
Yeah, maybe we might just jump to the next slide because I think we've got some photos that might assist people. So we've mentioned these 6 steps. We've very quickly run over some of the things you might need to do. But we've put together a guide because we realise, as I said, all the regulators are putting out all this information that's very much directed towards the top end of town and doesn't really practically tell you what you need to do. So we've broken down those 5 steps I mentioned, but we've also gone into far more detail about the practical steps that you can do. And then we've added what we call tools. Okay. So, for example, as we put up on the screen, handling complaints. We say there's 5 tools that might help you get through that step that's required. And these are things that you might need to do something with, but also you might want to keep on the shelf. For example, we've given you the first responder script and questionnaire. So if somebody does come to you with a complaint, pull that off the shelf, and that really helps guide someone through what are the questions you need to ask, how do you behave, how do you inform them about the next steps, what do you do with those tricky issues, like if someone says, hey, I want to stay anonymous, how do I
want to make a complaint but I don't want you to do anything about it.
Exactly. So that kind of helps with those scenarios. And then there's this big emphasis in complaint handling from the regulator on supporting people. So we help you address that issue by providing you with a fact sheet that you can give to staff, and also a fact sheet that you can have to inform you about some other steps you might like to take.
Okay, and I think there's some great videos from you and our colleague Rebecca in that package as well.
But we do note that it's hard to take on board all this content. There's a lot of it. It's very dense. So what we've done is we've put little videos for each of the steps. So if you want a refresher, or you just kind of think, I just want to listen to someone talk to me about it for a little bit.
Tell me about it.
Yeah, rather than if it's confusing to read, there's that avenue as well. So the guide is what we think is a very helpful tool to get you up to speed quickly. Because we mentioned 7 months is going to fly by. It contains 15 tools in total, and it covers off on these 6 steps, and it has 7 videos that match up with those.
And I can see as well, one of the questions that's come in is about that training piece as well. I know that in June, I think you're doing some in-depth training.
Yeah, very good point. And one thing about training that I've probably neglected to mention earlier, the expectation from the regulator is that employees are doing yearly training, so they're being updated on, as we discussed many a time, the new sex-based harassment offence and things like that. So as I mentioned, the knowledge section of the guide will assist you if you're wanting to assist with training employees on that. But for more senior people, the expectation of the regulator is that they do training every 2 years, but that it's in-person training, but helpfully online that's interactive is also covered. So if you're in that camp and you're thinking, I haven't done a refresher since pre-COVID, we've got some training coming up on the 1st and 2nd of June, and that might be a really good opportunity to get yourself up to speed and in a little bit more depth, because an hour is definitely, as you can tell, probably not enough to get across everything.
I do know as well, because I'm helping a couple of clients with it at the moment, we are able to assist if you have a group of people that you'd like in your workplace to get together. We can assist in that with doing one just for you as well. So feel free to reach out.
Yeah, and if you're wanting to get your board up to speed, that's another thing that a lot of people have been coming to us lately with, as we mentioned, that piece about leadership. If you do have a senior team who you're wanting an explanation of what the laws are and what they need to do at a more board level as opposed to an in-depth training for senior management, that's definitely something that's on the cards as well. And again, bystander intervention training, I think I must harp on about it because I just love it so much, but it is definitely another thing that we can offer.
All right. Well, I don't know that we've got much time for many questions. Is there anything come through that you want to touch on in particular, Tamsin?
I think The main questions about people are about the materials that have been provided, and my real suggestion, we've got a question about the risk assessment, the one that we put up on the slide, about the training materials and all of those kind of things. My suggestion would be, if you are interested in any of those, if you've kind of thought, oh, that's the hole I'm missing, or I need a new policy, definitely get in contact with anyone from the team, or just put something in the chat. I'm sure that the team will get in contact with you if you say you're looking for some assistance. But we're here to help, I think is the message.
Yep.
If you're overwhelmed by it all, if you're thinking,
a lot of information.
It is a lot. Get in contact. We're here to help, and we have taken the time to read everything, so you don't have to. So use us at your disposal.
Great. All right. Well, thanks very much, Tamsin. It's been a really interesting kind of hour of power, really, about legal obligations and then some practical steps as well. So thanks, everyone, for joining us today. Hopefully you found that useful. Hopefully you've got some ideas about where to go from here. And we look forward to you joining us in the future for further webinars.
Thanks.
Thanks.